What if I told you that after years of waiting, paying thousands of dollars in fees, and going through the entire green card process, your application could be denied because of how you signed your name? Not because you lied, not because you were ineligible, just because of one small signature mistake. This is not a hypothetical. This is happening right now. And starting July 10, 2026, the consequences are going to be even more severe. Welcome back to Immigration Updates today. If you are in the middle of a green card application, or if you plan to file one soon, please watch this video to the very end. This update affects you directly. This week, we are covering a major rule change from the U.S. Department of Homeland Security. It is called the new USCIS Signature Rule, and it was officially published on May 11, 2026. It takes effect on July 10, 2026, which means you have very little time to understand it and make sure your filings are correct. This rule changes how USCIS handles signature mistakes on immigration forms. The new policy is stricter. The consequences are more serious, and most importantly, in many cases, there may be no way to fix a signature mistake once your application has been submitted. Let us break it all down. What is this new rule and why did USCIS introduce it? First, let us understand why this rule exists. USCIS has seen a massive increase in signature problems on immigration filings. In the government's own data, signature-related denials climbed from just 300 cases in fiscal year 2021 to nearly 3,000 cases in fiscal year 2025. That is a tenfold increase in 4 years. The agency found two very alarming patterns. In one case, a company representative signed a blank sheet of paper and allowed a junior employee to copy that signature onto more than 20 different I-129 petition forms. In another case, a consulting firm pasted the same copied signature onto approximately 3,000 I-140 green card petitions. These are serious problems. And USCIS decided it was time to respond with a clear, firm rule. The rule was introduced as an interim final rule under the Federal Register on May 11, 2026. It takes full effect on July 10, 2026. What exactly has changed? Now here is the most important part. What is actually different under this new rule? Before this rule, when USCIS discovered a bad signature after accepting an application, the process was inconsistent. Sometimes they would send the application back. Sometimes they would deny it. Officers themselves were not always clear on what they were allowed to do. Starting July 10, 2026, the rules are clear and strict. If USCIS finds an invalid signature at any point, whether it is caught on day one or discovered months later during review, an officer now has the full authority to either reject or deny your application. And here is the critical difference between those two outcomes. A rejection means your application is returned to you. In most cases, your filing fee comes back too. You can fix the problem and resubmit. A denial is completely different. A denial means USCIS has reviewed your case, found the signature invalid, and closed the file. Your application may not be returned. Your filing fee may not be refunded. You may have to start the entire process over again with a new filing date and a new fee. And for green card applicants, that is not just money lost. This could seriously affect your priority date and your place in line, which in some countries is already decades long. There is one more critical point. Under this new rule, USCIS may not give you an opportunity to correct the signature after you file. If the signature is found invalid, USCIS is not required to send you a notice asking you to fix it. The only options available are rejection or denial, and the choice belongs entirely to the immigration officer. Which forms and which applicants are affected? This rule covers a wide range of immigration filings. It is not limited to just one visa type. The forms most directly affected include the I-485, which is the adjustment of status application for people applying for a green card while already inside the United States. It also covers the I-140, which is the immigrant petition for alien workers. The I-129, used for H-1B and other non-immigrant work visa petitions, is also on the list. Employment authorization documents, DACA renewals, and various other benefit request forms fall under this rule as well. If you are an employer sponsoring a foreign worker, this applies to you too. Many companies use automated document systems, remote signing workflows, or shared digital tools to handle large volumes of immigration paperwork. Under this new rule, those shortcuts carry real legal risk. Applicants from high-volume green card countries face particular exposure here because they represent the largest group in the employment-based green card category, and many of those cases involve remote document signing between employees, employers, and attorneys across different locations and time zones. What signatures are accepted and what is not allowed? Let us be very specific here because this is where people make mistakes. USCIS accepts a handwritten signature. That is the standard. You physically sign the form with a pen. That signature is valid. USCIS also accepts a photocopy, scan, or fax of an original handwritten signature, as long as the copy came from a document that was actually signed by hand in the first place. So if you sign a paper form, scan it, and send it in. That is fine. USCIS also accepts electronic signatures, but only through forms filed inside the official USCIS online filing system. Now here is what is not allowed. Typed names are not a valid signature. If you simply type your name at the bottom of a form instead of signing it, that will be rejected. Signature stamps are not accepted. Auto-generated signatures produced by software tools are not accepted. Signatures created by someone copy-pasting an image of your signature onto a form are not accepted, even if the original image was your own real signature. Most importantly, someone else cannot sign on your behalf in most situations. That includes your attorney, a family member, or a company employee who does not have proper legal authority to represent the petitioner. In most cases, you, the actual applicant or authorized petitioner, must be the one who signs. What could happen if you ignore this? The consequences are serious, and they go beyond just losing money. You could lose your filing fee entirely. Green card fees are not small. The I-485 alone costs over $1,000. When you add biometrics, medical exams, the I-140 petition, and premium processing if used, the total cost of a green card application can easily reach several $1,000s. If USCIS issues a denial, all of that money may not be refunded, simply because of one invalid signature. Your priority date could also be affected. For applicants from countries with long green card backlogs, the priority date is everything. It determines your place in line. If your application is denied and you have to refile, you get a new filing date, which could mean losing years of waiting time. You could lose work authorization. If your employment authorization document renewal is denied due to a signature issue, your ability to legally work in the United States may be interrupted while you refile and wait again. And if you are a company, a signature-based denial can disrupt your entire workforce planning, delay employee onboarding, and create compliance problems you were not expecting. What should you do right now? Here is what you need to do before July 10, 2026. First, if you are planning to file any immigration benefit request, whether it is a green card application, a work visa petition, or a renewal, make sure every required signature is a genuine handwritten signature from the correct person. Pick up a pen, sign the form yourself. Second, do not use DocuSign, Adobe Sign, or any other commercial signature software on paper-filed forms. These electronic tools are not accepted for paper submissions to USCIS. Third, if you are an employer or HR team managing immigration filings, audit your signature workflow today. Make sure you know who is signing, how they are signing, and whether that person has the legal authority to sign on behalf of the company. Fourth, keep records. Attorneys and compliance experts recommend keeping original signed documents on file for at least 6 years. If USCIS ever questions your signature later, you want to be able to show them the original. Fifth, if you have applications currently being prepared, do not rush. Give yourself time to sign correctly, review the documents carefully, and double-check everything before submission. A small delay to get it right is far better than a denial that sets you back years. Finally, If you are unsure about whether your signing process meets the new requirements, speak with a qualified immigration attorney before filing. This is one situation where professional guidance can prevent a very expensive mistake. Let us quickly summarize what we covered today. On May 11, 2026, the Department of Homeland Security published a new interim final rule on USCIS signatures. It takes effect July 10, 2026. Under this rule, USCIS now has full authority to deny, not just reject, any immigration application that has an invalid signature, even if the signature problem is discovered months after the application was accepted. If USCIS issues a denial on signature grounds, your fees may not be returned and you may have to start over. There is no guaranteed cure or correction once the form is filed. Valid signatures must be handwritten from the correct authorized person. Typed names, copied images, software-generated signatures, and stamps are all invalid. This affects green card applicants, H-1B filers, work permit renewals, and many other categories. Employers who sponsor foreign workers are also directly affected. That is everything you need to know about this important USCIS update. Please take it seriously. One simple mistake on a signature line can undo years of hard work and thousands of dollars in fees. If you found this video helpful, please give it a like. It really helps this channel reach more people who need this information. Share this with anyone you know who is going through the immigration process right now. They need to see this before July 10. And if you are not subscribed yet, please subscribe and turn on the bell notification. We post immigration updates regularly so that you are never caught off guard by a rule change. Stay informed, stay compliant, and we will see you in the next video.